Welcome to the webinar on dispute resolution. Gonzalo, would you like to say some opening remarks?
Thanks, Anarela. Hello, good morning, good afternoon, everyone. Welcome to this relevant webinar on dispute resolution. My name is Gonzalo Arias. I'm the International Cooperation and Taxation Director at CIAT, the Inter-American Center of Tax Administration. For those who don't know what is CIAT, CIAT is an international public organization that groups 42 countries from America, Europe, and Asia. Our objective is to promote cooperation among tax administrations and to give support to tax administrations. In particular, for CIAT, it's key to improve the knowledge on dispute resolution mechanisms among its developing member countries to support them to face the challenge imposed by the context. You know that the tax systems are characterized by complexity and give uncertainty in almost all countries around the world. That's why the cooperation we have with Tribute, in particular with my colleague Hans Muich, is more than relevant to meet our goal. For those who don't know, Hans Muich, he's a tax expert, he's professor in different universities in the Netherlands, and he's former tax official, and he's the chair of this organization, Tribute. He will comment after my presentation. We are also deeply grateful with the experienced professional we will have the pleasure to listen to during this webinar. Ladies first, I will start with Liselot Cana. Thanks, Liselot, for to be part of this activity. She's from Chile. She's the head of the International Taxation Department in the Tax Administration from Chile and expert in tax treaties. Natalia Quiñones is from Colombia. She's partner at Quiñones Cruz Attorneys. She's former tax treaty negotiator in the tax administration from Colombia. And we had the pleasure to have Natalia as CIAT correspondent in the past year. Timothy McDonald is from the USA. He's currently the Vice President of Finance, Accounting, and Global Taxes in Procter & Gamble at the US. Thanks, Timothy. Philip Baker is from the UK. He's Queen Counsel, barrister and tribute expert and visiting professor in Oxford University, UK. Partho Shams is from India. He's the chairman of the International Tax Research and Analysis Foundation. He's former Minister of State in India and former chairman at Tax Administration Reform Commission in India, visiting fellow in London School of Economics. Finally, Juan Carlos Trujillo is from Mexico, and he's Deputy General Director of Tax Treaties at the Ministry of Finance in Mexico. So as you can see, we have a first level professional panelist, so we can assure the success of this activity. They will give us their perspective on international good practices, regional good practices, and the business point of view, and some domestic aspects about this issue. It's a pleasure to have more than 500 participants interested in discussing and increase their knowledge on this issue, dispute resolution. Well, I have to thank, I want to thank Anarela Calderoni from CIAT. You did a great coordination job, and the CIAT staff, Maureen Perez and Cesar Trejos, who are giving us technical support in this opportunity. I have personally high expectations for this webinar at the first CIAT Tribute step to promote effective mechanisms to resolve and prevent dispute on cross-border and domestic taxation. Before finalizing my opening remarks, I would like to give you two messages. The first one is to ask you to please change your name using the rename function in your screen where you can see your face or your name, and change the name using your name, then surname, and the name of your organization. If you are from public organization, If not, you can put the name of your country. As you can see in my picture, Gonzalo Arias, CIAT. The second one is that at the bottom of the screen, you can see two chats. One of them, well, I can see the name in Spanish, but not in English, but one chat is in the left, where you can comment and discuss about the presentation of the experts. And the other one is on your right, is just to formulate questions to the experts. If you formulate questions to the experts in the other chat, we will have to disregard the question. So please try to respect the objective of the chat. Now I have the honor to give the floor to my colleague, Hans Muich. Please, Hans.
Thank you, Gonzalez. It's a pleasure for us at Tribute to join you in the organization of this webinar. And we're very happy to assist with our facilities and experts. Any further efforts as CIAT has wished to undertake in this particular area. For all your viewers and participants, I would like to point you out to the Tribute website, tribute-arbitration.org, where you can find elaborate further information on the Tribute organization, its participants, and its goals. I want to issue just, let's say, a small remark on the importance, the major importance of the issue of dispute resolution. I mean, just the other day, the OECD Secretary General, Mr. Angel Gurria from Mexico, warned the world against tax disputes and trade wars. Now, this was in reaction to the United States suspending its participation in the discussions on Pillar 1 of the OECD proposal for a unified approach, the taxation of the digital economy. Tax disputes and trade wars, well, that is a grim outlook indeed, and let's hope it doesn't come that far. My remark, however, is that the situation might have been less grave had there been a global dispute resolution mechanism in place. But sadly, there's none. Now, resolution and prevention of international tax disputes has been an area of neglect for many decades. But now, the OECD, under the unified approach, pushes for mandatory binding arbitration as an essential of a new global tax order. Arbitration can be a perfect solution under certain circumstances. And that's what my organization stands for. But I'm saying arbitration is not a panacea for everything and not for everyone. And you know who that comes from, right? Now, Latin America, as the wider developing world, are demanded to improve on their tax dispute resolution and prevention. That's clear. The case of developing countries, though, poses special challenges to the design and implementation of dispute resolution and prevention instruments. If you want to make them match with the particulars of developing countries' cultures, laws, abilities, and resources. There is no lack of commitment among Latin American authorities, and I'm very happy to note that. So all I want to say is, well, let's start working then, right? Further to you, Annarella.
Thank you very much, Hans. I think that's all the introduction we need. Why don't we start with the first session, which will be Mr. Timothy McDonald and Mr. Juan Carlos Trujillo.
So I guess I'll start. Juan Carlos and I agreed to spend the next 10 hours talking about dispute resolution. I'm just kidding. We're doing a 10-minute introduction, open dialogue with the panelists, and then we'll take questions, I think, towards the end. If we could move to the next slide. I allude to 10 hours as a symbol of how the MAP process works. It's the current treaty dispute resolution mechanism is, in many cases, our only international mechanism to relieve double taxation, but it's by far the least efficient compared to avoidance. So my first slide is to describe a little bit of the thought process that we have, or at least one tax executive has. I'm not really speaking on behalf of P&G, but as someone who's been in taxes for over 35 years, and for the last 22 years, the head of tax at 2 different multinationals that are Fortune 200. P&G has a very large global reach, so I'm describing experiences from a lot of countries over the last 17 years that I've been at P&G. Our favorite approach is advanced pricing agreements. In effect, don't wait till the audit, get it agreed upon at the front end. It does require energy, and it does require, the right circumstance for this to make a logical choice. It comes with the commitments that you have full disclosure and the assumption that nothing will materially change, because these rulings have no value if there is a material change in the business model or economic circumstances. The economic assumptions of the market are often in an APA as well. The advantages are that you can potentially not only solve the future uncertainty, but you may even, in many countries, use the APA mechanism as a MAP rollback as well, if you have open years or potentially even an open audit dispute. It certainly is predicated on transparency. The rulings have no value if you don't disclose all the material facts. And I think it's pretty clear that in order to have a real ruling, you need to, can we go back to the intro slide? Thank you. If we could, oh, I lost my train of thought. The business substance is clearly a requirement these days. If you're going to try to get an advanced pricing agreement, typically these days, it's not a one-sided review of the transfer pricing. That might be the primary method, but our experience is the government's requests and we provide access to things like system profit and what the other parties are doing and what they're receiving, so that there's a proportionality in the allocation of the enterprise profits. So, yeah, I think you can think of advanced pricing agreements as the best demonstrated dispute prevention. I'll explain a little bit of the profile of why pick it, why do APAs in a moment, but it's not the only mechanism. I think it's also increasingly possible to get some of the benefits of an APA without the same level of investment on the government or the taxpayer by doing a risk assessment, cooperative compliance, horizontal monitoring. They name them different things in different countries, or in the OECD case, ICAP, International Compliance Assurance Program. We were a pilot member of the first round of ICAP. We had 6 countries participate, the US plus 5 others. We had previously been low risk designated by 3 other countries, and we have 2 more pending. So we do believe in these risk assessment tools. I think they don't provide the same level of contractual protection that an APA does, but they're of value. You're coordinating with the national office, just like an APA. The national office personnel is generally more trained, more experienced. Generally, someone in the national office has responsibility for the treaty map procedure, and they're therefore more familiar with international commitments and norms. There's a professionalism about it that is generally more predictable. So we tend to like these national office transfer pricing approaches. In full disclosure, we're also the type of company that's audited in many countries every year. And so for us, the question isn't, will we get audited, but on what terms and how we schedule it. And if every country we operate wanted to audit us in the same time, we could not respond to their document requests. It would overwhelm our system. And advanced pricing agreements also give us the opportunity to schedule the work to some extent, and it allows us to smooth out the workflow. So on balance, we think those are both worthwhile programs. As we did our prep, we also had the discussion in a couple of our sessions as to how does a multinational think about all this? Why cooperate? Why negotiate? Why litigate? And to be honest, at least my assessment, how we approach it is, if we have a weak case, we don't pursue it at all. If somehow we got ourselves into it by inadvertent mistake, it's time to surrender if it doesn't have merit. I want to have only credible, strong cases on the table, and the weak ones take your resources, and your probability of success is low. So it's not a strategy that we pursue. If we think we don't have all the ducks lined up in a row, we settle. In some cases, just full surrender. And there's no, in my mind, there's no mistake in that strategy. That's the right way to allocate my resources. Conversely, if we feel that there's high merit to our position, and particularly if it has global repercussions of being replicated, we can't accept an unprincipled settlement because it undermines not just that country's tax economics, but potentially it's spread globally. And so in those type of circumstances, we will definitely pursue aggressive defense of our position, and we will assess how viable are the courts, and we'll assess the strength of our case and decide what's the right avenue to remedy the case. But for us, it's pragmatism. I'm a firm believer from a tax standpoint that we don't have to be right, we have to get it right, which means my personal ego is not part of this solution. If we have to settle a case, we should. So why don't we flip to the next slide? I mentioned APAs and dispute prevention, and I alluded to some of the reasons we do it. The national office strength is certainly one of them. For us, because we're a large taxpayer in many countries, it's also not a question of whether we get audited, but it's more about controlling the scheduling. We also value, particularly in the cooperative compliance space, the validation that being designated a low-risk taxpayer gives to us from a corporate reputation standpoint. And lastly, I'll touch on something that's not as obvious, which is quality of earnings. Generally speaking, particularly transfer pricing, there is no correct answer. There's a range. And the range concept requires multinationals to carry tax reserves. And even if you think you're right, even if you think you're in the middle of the interquartile range, and therefore, in theory, untouchable, the tax authorities often will have a different set of comparables, different comparability adjustments, and there's always some room to discuss is the actual result where it should be. That means that for large multinationals, we have a lot of tax reserves relating to transfer pricing, but for a dispute prevention mechanism. And so to give you scale, we're over $70 billion in sales in the US, and we make about 15 billion in profit worldwide pre-tax. So we're a very successful large enterprise. And if you went back about 12 years before we aggressively went after APA programs, we were carrying about $3 billion of tax reserves, and most of it was transfer price reserves. And it was because of every market we're in, the uncertainty of the range, the multiple years, potential for interest and penalties. It just really is a lot of money. And so what that means is in years 1, we have to have less after-tax earnings as we fund the tax reserve. And if we prevail 5 or 6 years later on audit, we release them to earnings, but the US GAAP accounting in particular calls out that release from a prior year return. And the analysts look at it and they don't know what to do with it, so they ignore it. So over the course of a decade, if you have a lot of transfer price reserves and then you release them, in effect, you don't have the same amount of reserves or same amount of earnings over 10 years as if you had gotten that uncertainty out of the system. And so we're actually of a philosophy that we give a little bit more to the market jurisdiction for a distributor return than what our aggressive position in a study would justify. Because for us, the value of certainty is more important in eliminating these tax reserves and the uncertainty for the operations than it is to give up a little bit of the gross margin to the destination market. So the quality of earnings component of APA strategy is a corporate perspective that we embrace, and it's one that my CFO absolutely loves. So he's encouraging us to ever increase our APA network. We have 16 countries with bilateral APAs. We have 9 more pending, many in markets that have not done this before in developing countries. And our goal, we're approaching the point where 80% of our cross-border transfer pricing is covered by rulings. So that gives us a high level of earnings quality that we think is worth doing. Lastly, the difference in the 2 programs. APAs, if everything's disclosed correctly and nothing materially changes, a bilateral APA should be viewed almost like a contract. It resolves it for a period of 3 to 5 years. The cooperative compliance programs are a lighter audit, a lighter touch, and therefore a lighter level of assurance for the taxpayer. I could not convince our auditors that a cooperative compliance ruling would mean that much for my tax reserves. But my APA network does mean a lot. If you looked at our financials, I alluded 12 years ago, 13 years ago, we had $3 billion in tax reserves. We've resolved almost all our cases globally, other than a few markets with low values. And as a result, our tax reserves are now about $750 million US dollars for all open years, interest, penalties, everything. And that's a very small fraction of our cross-border flow. So that's kind of the difference in the programs. Now I'll go to the next slide. Wrapping up, these were all taxpayer perspectives on dispute resolution. What about the governments? Well, we've always had the possibility of a treaty and a MAP mutual agreement procedure. And some of those treaties have an arbitration clause, at least in the US. One that's really worth taking a look at is the MAP and APA backlog that existed between the US and Canada for well over a decade before the US-Canada revised treaty protocol was passed, which incorporated an arbitration clause. And within 2 years of adopting that clause in the protocol, the backlog largely evaporated. And both governments aggressively tried to resolve cases without sending them to arbitration. The arbitration in the US treaty with Canada, and Philip Baper is going to talk about this much more, but its nickname is baseball arbitration, but it's last best offer. And what that really means is when the arbitration panel hears the case, each side presents their best offer and the panelists have to pick between them. And so the strategy is to be as reasonable as you can to protect your position, but be reasonable, because if you're slightly less reasonable than the counteroffer, the other side wins everything. And not only does that resolve disputes quicker, it actually is a very strong preventative medicine, because generally the administrations do not want to have an arbitration case because they don't know how it will turn out. And it could be more embarrassing than a settlement. So it has organizational dynamics within Hacienda House or the Treasury of each government that has these programs. I'll mention BEPS Action 14. I think the peer review has been very helpful. This is a government-to-government OECD-sponsored inclusive framework effort to try to make sure that the MAP procedures work better. And they're reviewing both the quality and quantity of the caseload. And I think it's improved behavior, not dramatically, but helpfully. And lastly, we have the digital project. And here I'm going to sound like an optimist in the extreme. If done aggressively, I think Pillar 1 could resolve much of our cross-border dispute system legacy debates. Amount A reallocates some system overall profit, however measured, to destination markets outside the arm's length standard. I view that as sort of a peace dividend payment, that it doesn't follow transfer pricing methodology, but if this is what it takes to get certainty and dramatically reduce the dispute, cross-border disputes, I think it's worth doing. Amounts B, particularly if it's formulaic, could drastically simplify transfer pricing. And if it's reasonably close to an arm's length result, I think it'd be a vast improvement in how transfer pricing is done, particularly for distributor returns, which is its focus. I'm told that of all the MAP cases globally, approximately 60% of the cases are distributor return cases. So it could dramatically free up resources and solve a lot of disputes. And to the extent there is still disputes left, Amount C takes an approach. We'll see where it goes. But there'll be different types of offer. If I were writing the paper, I would say, let's have a menu of choices, and the countries have to agree between them which one they pick. They could have mediation. They could have classic arbitration. They could have last best offer. Perhaps the OECD could have permanent loan staff with inclusive framework participating countries to provide technical support to countries that haven't done it before, or that haven't had a lot of cases or need the transfer pricing expertise to build up a case. And lastly, I think peer review of all this might be helpful as well. So I know it's a challenging time. We've never seen more anarchy in tax policy, but it's also an opportunity to reorder the House and perhaps drastically reduce the amount of disputes. So I'm trying to be optimistic about the digital project. On days it somewhat challenges me, but I think looking forward, it still has the potential to do a lot. Juan Carlos, why don't you take over?
Thank you, Tim. Definitely, it's very interesting. It was very interesting your presentation. Before I start, I wanted to thank the organizers for the invitation, and it's great to see some familiar faces and names during this time. Just a general comment before I start on this resolution. Definitely, it's an issue that has been discussed for several years. Different efforts have been made on different fronts. However, it has the discussion has kept evolving, and well, it has managed to stay a very relevant issue during these years. I will start by providing a brief overview of the situation in Mexico regarding the mechanisms mentioned by Tim and our experience regarding them. And then we will touch on some of the most relevant aspects that we think there are currently and into the future. So regarding the Mexican experience, I will start with APAs. In Mexico, we have APAs since the 1990s. And I would say that we have a significant experience regarding them. Just to give you a number, for the period of 2017 to 2019, there were 560 requests for APAs in Mexico. But there is a reason for it, for this high number. And it is that in Mexico, we have an important sector is that of the maquiladora sector, or the manufacturing company sector. And these companies will receive goods and merchandise, and they process them and manufacture them and return it to the final product to the US mainly. So these maquiladoras have a special regime in our domestic legislation, and that regime produces this high number of APAs. In our country, that technically they are unilateral APAs. However, they are resolved based on a previously agreed memorandum of understanding with the IRS. So only the tax administration resolves them, but based on a methodology agreed with the IRS. So I would say that there is a certain bilateral aspect to it. Mm-hmm. In Mexico, these APAs are valid for the year which they were agreed, for the 3 subsequent years, and we have a rollback of 1 year. And that is the default rule according to our legislation. However, this period could be extended through a mutual agreement procedure under tax treaties. What else? The APAs have to be resolved within a period of 8 months, according to our legislation. This period could be extended if additional information is required to the taxpayer. And in our case, the only competent authority that can resolve these APAs is the transfer pricing department within the tax administration. So unlike other countries, there is not an autonomous body or independent body that can also review APA requests. It is only the transfer pricing department within the tax administration. I think that would be the summary of APAs in our country. Now, going to ICAP, I think that is an interesting program. I think that not many Latin American countries are familiar with the program. I would say it is, as I understand, a risk assessment program where multinational enterprises of countries that participate in the program voluntarily provide information regarding certain activities and transactions, and relevant tax administration review that information and could consider that those transactions and activities as low risk transactions. I think that's the objective of the program. I think that whenever taxpayers and tax administrations, when they have an open, transparent, and cooperative communication, it's a win-win situation for both of them. However, I think that the program is not for everyone at this stage. I think that at least for the case of Mexico, and I think some developing countries probably, in order to fully commit to that program, it requires well, significant resources, I would say. From the human resources part, at least, it requires a very capable, experienced, qualified team to be able to analyze this information. In Mexico, there are these officials that are very, very capable and specialized in transfer pricing. However, the current workload that they have on a day-to-day basis is very significant. So if we add to them the commitment on ICAP, which has very ambitious timeframes, I think it will be difficult to comply with them. So at this stage, at least for Mexico, it is not feasible to participate. We have been invited to participate and to hear the experiences of other countries regarding this program. But at this stage, as I mentioned, it is not possible. However, this doesn't mean that in the future, if the circumstances change or if an opportunity presents itself, I know for sure that Mexico will be interested in joining the program, or if there would be some simplified version to it, or where probably more basic information could be exchanged. I think that is something that could be looked at. Regarding in Mexico, as changing the subject, in Mexico, we have also an alternative dispute resolution mechanism under a tax ombudsman agency, which is called PRODECON. And the procedure is called Acuerdo Conclusivo, or Conclusive Agreement. And it has become a very popular procedure in Mexico. Since 2014 up to date, there have been 12,000 requests for this procedure, which is a mediation procedure where the taxpayer that is subject to a tax inspection requests the participation of this independent body, that is PRODECON, in order to mediate between them and the tax authority. And whenever a request is made, it suspends the timeframes of the tax inspection, and it produces different advantages. I would say this procedure, as it is definitely a quicker procedure. In average, they are resolved in a period of 9 months, and to this date, 2/3 of the cases, in 2/3 of the cases, an agreement is reached between the authority and the taxpayer. And it also will saves time and money, I would say, to the taxpayer. This shorter time frame, I think it saves them for certain costs, at least fees for tax advisors and other costs. And in the perspective of the tax authority, it is also an effective procedure, as it resolves cases quickly, and it lessens the workload for the authority. And for the period of also to give you a number, for the period of 2014 to 2018, the tax administration collected over $1 billion under this procedure. So it is also, from that point of view, an interesting procedure in Mexico. Now going to the question of maps in our country. Well, first I would say that I agree with what Tim mentioned. I think that whenever mutual agreement procedure doesn't have an arbitration mechanism, mandatory arbitration mechanism, there is a weakness in there, as authorities are not required to reach a solution, and that can result in double taxation, and uncertainty is increased regarding the interpretation and application of treaties. However, as you know, there is in Latin America and in developing countries skepticism regarding the application and a reluctance to accept arbitration. There are different reasons for it. Hans mentioned some of them. I think there is a lack of capacity in some cases, lack of experience, lack of resources. There will be costs associated to arbitration. Fees will have to be paid to arbitrators, and travel expenses and logistics. So these are issues that have to be taken into consideration. Some countries still have an argument regarding tax sovereignty regarding arbitration. So these, I think, arguments all pile up, and it has resulted in developing countries, I would say, not accepting arbitration still at this time. In the case of Mexico, we have a treaty network of 61 treaties at this time, 11 of them have an arbitration provision, but it is a voluntary arbitration provision. And in practice, it has never materialized. We've never had arbitration. We've had some treaties with most favored nation clause. So whenever we decide to go for mandatory arbitration, we would have to negotiate with these countries. They are mainly European countries, the Netherlands, Belgium, Spain, and some others. So it is something to take into consideration when we have this analysis of going into arbitration or not. What else? I have to say that within the framework of the MLI, we really took a close look into arbitration. We recognize the benefit of tax certainty that it provides. However, for us, it would have resulted in having 20-something treaties with arbitration all at once through the MLI. So we prefer to have a case-by-case approach, and that whenever we decide to go with arbitration, it will be the result of a bilateral negotiation. And also, I agree with what he mentioned. From our point of view, the best approach for arbitration would be baseball arbitration, or final last best offer arbitration. We think that is a simple procedure that saves time, saves money for the participants. And so I think that it presents good advantages for countries that use this type of arbitration. Finally, with respect to the digital project work that is ongoing, I think that many of you would be familiar with this work. Currently, 137 jurisdictions are participating in it. It is an ongoing work. It has a target to be agreed in 2020. I think there are some doubts currently regarding if this time frame will be met, but I think it has the potential of ending up in being a game changer regarding mandatory dispute resolution. There could be cases where a tax dispute involves a very large number of jurisdictions, and even between jurisdictions that currently don't have a tax treaty between them. So this requires an innovative approach to resolve these cases, to provide certainty to the parties, and I think it is a very interesting time ahead for our countries. I think in summary, this is a quick review of our experience and our situation regarding dispute prevention and resolution mechanisms. I think that now, I don't know, taking advantage of the having a business perspective, which I think it is always very interesting. I wanted to ask you, Tim, if what has been your APA and MAP experience comparing pre-BEPS, before BEPS, and after BEPS? Have you noticed an improvement there regarding APAs and MAPs? A lot of work was put regarding Action 14 and a minimum standard and peer reviews and all of that. Have you really noticed an improvement there?
It's hard to discern, in part because we've got a pretty established APA profile. We have one business model pretty much around the globe. We've got some of the best tax administrations have all looked at the APA ruling. They come out remarkably similar, and therefore ours tend not to be as difficult, I think, as some who have either unusual fact patterns or multiple business models that it doesn't scale as easily. Our experience in APAs is all over the board. So in theory, these are generally 5-year rulings, prospective, but you don't get 5 years protection. You get 5 years typically from the day you file. And our experience is that in a number of countries, the ruling took more than 5 years. So the A of APA, the advanced part, didn't exist. And so you'd say, well, why are you doing this? And the reason is, when the parties invest that much to get to a resolution, they quickly say, well, let's not do that again anytime soon. And they'll renew the second one quickly. So the US, the UK, and Japan all were 7-year APAs from start of the controversy to a signed APA. But we got resolution of all those open years plus 5 years going forward. So by the time we resolved them, we resolved like 12 years of open tax audits, which was, very, very important for us. A couple of countries would look at the development of the file from all these other neighboring countries, particularly smaller countries in Europe, and they may not spend as much time if they're the 8th APA ruling in Europe. So the experience of how long it takes varies by country. You mentioned the cost. The cost is real for both these projects, for both the government and the taxpayer. One of the advantages of the APAs is it's acceptable in most countries to charge a fee for the ruling. And the reason for that is it's voluntary and the government is providing you added, certainty. And if you ask them to put the extra time in, they are comfortable within their legal system of charging the applicants a fee. And in a number of countries, that fee goes to that department. So it funds the funding of a annual database subscription and the hiring of personnel. And for at least a large multinational, even though these fees can be as much as, say, $100,000, relative to the amount of years at stake and the tax uncertainty, we pay it and we have no problem paying it. So on the margin, if the governments are thinking of options and they're interested in this, I think hard about setting up a fee system. And you can have a smaller fee for smaller multinationals or companies based on their size. I think that's generally accepted as well. The US does that as well as other countries. So broadly, I'd say it's hard to generalize both APA and the certainty programs like ICAP. I think on balance, the APA renewals have been a little bit of wait and see because of the digital project. They haven't stopped, but if there's a significant change in the international landscape, at least some of the governments are less eager to go quickly renew the ones that they've already got in place. We tend to get the renewals. It's not that they're not happening, but the velocity seems to have slowed down. It takes a little more energy to get the renewals than it did 2 years ago, but I don't think that's a BEPS issue. I think that's a digital uncertainty point, which hopefully the book that they come out in October and the path that yet to be revealed might provide the breakthrough, and then we'll get back to normal.
Yes, I agree with at least from our experience in just comparing BEPS, pre-BEPS and post-BEPS. I think that at least in the case of MAP, there has been an improvement. I think that now it is more difficult to at least deny the access to MAP. Yeah. Because of the statistics that you have to report, and you have to justify whenever you deny an access to MAP, and also the issue of as a minimum standard of having the time frame of an average of 24 months. I think Mexico doesn't comply yet. We have an average of 30-something months in our MAP caseload, but this puts, I think, an incentive for countries to be within that time frame, and it as a consequence it benefits the taxpayers, as it doesn't now go like these prior cases of 5-6 years of having a MAP and uncertainty and double taxation and all of that. I think from that perspective, it has helped the work on Action 14.
Yep.
I think I don't know if time we are a bit close to ending, but I think an important question for the future What I think that now with this
Juan
COVID,
Carlos, sorry for the interruption, but we exceed the time for the panel, so take just 2 minutes or 3 minutes.
okay, thank you,
Sorry.
thank you. Yeah, just a quick question for Tim. What are your expectations in life after COVID-19? I think that most of the countries after the pandemic will have a necessity of with respect to or financial pressures, that they will have some additional financial pressures after the pandemic, and a need to have an increasing tax collection. So do you expect a change in the tax behavior of tax authorities after this pandemic?
Yes, there's no question there's going to be more revenue demands, and it'll be to each country a political decision as to how to raise that money. I would advocate looking at World Bank and OECD and IMF, who all have an unusually common voice saying that the corporate income tax tends to be the most distortive in that it causes asset reallocation when it's out of sync with the competitive norm. So things that are border adjusted have less distortion and the higher potential to get the investment capital to grow. And part of the solution is we can't have a world economy growing at 1%. The revenue demands are very ugly if you don't have growth. So I think a policy that has one eye on growth and one eye on equitable revenue raising, it's a difficult political choice. I suspect in some countries it'll be biased more heavily to consumption taxes, and others will bias it more heavily towards corporate income. But with all the governments collectively now, the sovereign debts equal world GDP, we're at a point where we just won't be able to keep doing this. And there'll be a need to revisit post the pandemic how to fund governments in a way that meets the needs and yet doesn't kill the golden goose.
Yes, I think it will be very challenging for countries. I think a dilemma could present for tax authorities. I think for one side, they could want to be they could want to have a more attractive investment climate. And going into our topic, that could mean probably for some countries for accepting arbitration. I mean, that favors having a more certainty and a better investment climate. On the other hand, it could mean in tax audits, for example, having a more strong positions regarding audits in order to collect more. That could create more suits, and that I think that's a dilemma that could present between for tax authorities.
Yep.
Thank you both very much. That was very interesting discussion. I think we can move straight on to the second panel. But first, I just wanted to let everyone know that you are welcome to ask questions, which will be answered at the end of the webinar. And you can also ask them in Spanish if you want, because I know we have a lot of people from Latin America. So if you want to throw out your question in Spanish, that's okay too. And now onto the second session, which is Partho Shom and Lisa Latkana. Is everyone looking at the PowerPoint? Yeah, perfect. Okay, we can start. Thank you.
Thank you, Anarella. I want to start by thanking Hans Muj for originally approaching me, and to SIAT, particularly to Gonzalo Arias and Anarella Calderone of SIAT. My association with SIAT goes back, I was counting, for about 3 decades. So I'm very happy to be associated with this webinar. Having said that, let me very quickly get to my first slide, Anarella. Firstly, I wanted to say that my topic says developing countries, and whenever I see that phrase, immediately I like to draw the attention that there are actually significant differences in the priorities and approaches among and within developing countries and emerging economies from the point of view of their tax administrations, as well as their preferences in international tax policies and not only administration, but also policy. Sometimes they may appear to be similar, but when you look into them, there may be minute or very small differences. So this is the first thing to keep in mind. For example, India, South Africa, Indonesia, their priorities and experiences are quite different from those of, let's say, Chile, New Zealand, Singapore, or Taiwan. The smaller countries fit more easily into the global mold than the larger ones because probably of their greater dependence on international trade, whereas the larger countries are somewhat different in priorities. Third, the alignment of the economic growth as an emphasis of governments vis-a-vis the revenue protection by tax administrations is different in different countries. The smaller country administrations are probably a little more market concerned than the larger ones. There are always tensions in the larger countries between tax administrations and the policymakers of the economy. So these are my initial observations to keep in mind the idea of putting all developing countries in one basket. Actually, they are quite different. Could we go to the second slide? Yes. Now, I want to go more directly into the map experience. I think Liselot will be speaking from the point of view of Chile. I will therefore take up India as kind of two case studies, so to speak. And first, I begin with map and the publication of map statistics. For example, even here, while many countries are publishing map statistics by themselves, you see countries such as India and Indonesia don't do it, though the OECD provides some information on them. To take the case of India, for example, the case load of map at the beginning of 2018 was 460, and at the end it was 418. So only 42 cases were closed during that year. Other cases, these cases refer to transfer pricing cases, but other cases started with 97. There were no cases that were closed during the year, and at the end of the year, they were still 97. So you see that in the smaller countries, there's always kind of pressure to close and so on. In India, for example, certainly the speed has been increased, but the speed is not increased to the extent that you find in other types of developing countries. The second point is that of intersection with domestic law. In India, the question has been which takes precedence, the domestic law or everything that is coming out of treaties and BEPS recommendations and so on. The tax administration has taken the view that domestic law will prevail. So where the question is, where domestic law is actually less stringent. For example, in India's GAR, when GAR is examining corporate structures, it should be looking at the main purpose. That is the criterion. Whereas we know that in PPT under BEPS, the criterion is one of the main purposes, not main purposes. So in this case, you see the international criterion is more stringent than the Indian one. So the question arises, in such a case, will Indian domestic law also prevail, or will the authorities really opt for guidance from BEPS and the BEPS actions? So there are these issues of domestic vis-a-vis international, and they are not yet resolved in India, and there are very strong opinions about them. Third, the limited availability of infrastructure resources. One reason that international participation, international guidelines, international follow-up in continuous debate and so on, that Indian tax authorities shy away from, or have historically shied away from. One reason is the high financial and staff resources. These are real issues, and especially in arbitration, when compared to multinational enterprises and advanced country tax administration that can spend more easily in an international forum. But slowly, countries like India, Indonesia, etc., they are coming to international participation, seeing that this is the new practice, and in some ways they have to be pursued. Next is the inclusion of Article 9.2 in tax treaties. Again, historically, how the next, oh no, it's the same slide. Yes, inclusion of Article 9.2 in tax treaties. Here, the issue is that, historically, India actually never allowed in its treaty policy the settlement of transfer pricing disputes via maps or APAs. So with countries where Article 9.2 was not present, for example, in treaties with Brazil, France, Germany, Singapore, and others, taxpayers were left out in the cold, so to speak, and suffered double taxation. But India actually revised its position recently in November 2017, and to comment on the fact that whether BEPS has affected, certainly this was a case that came from the BEPS, that it was it rose in the context of BEPS, and the Central Board of Direct Taxes now accepts transfer pricing map cases and bilateral APA applications, even if Article 9.2 is absent from double taxation avoidance agreements. So this is a major way in which I think BEPS actions, and then also pillars and so on and so forth, are affecting and internationalizing India's approach to international tax policy. Of course, Action 14 is a minimum standard. Therefore, map access is a minimum standard in a way. But what happens, whether it is compulsory and so on and so forth, mandatory, is another issue. Now, most tax treaties in India are in accordance with OECD's Article 25. That is, by definition, no double taxation exists. In such cases, India doesn't agree to involve MAP, so to speak. This is because this goes, according to India, beyond the terms of a tax treaty, because the tax treaty itself is saying that there'll be no double taxation. So to go and take the recommendation of BEPS goes way beyond the double taxation, that is avoidance of double taxation, that is already in the tax treaty. Therefore, you can see that the approach of countries like India, South Africa, Indonesia has been much more cautious than many other smaller emerging and developing countries. The next slide, please. Yeah. Now let us look at a little bit at the mandatory arbitration. In fact, I consulted, when I say experts view in India, I consulted some of my professional colleagues in India, including Mukesh Bhutani, who is now president of IFA India branch. And from his writing and correspondence also, they do prefer mandatory arbitration. So as opposed to the tax administration's position, where the tax administration has made a reservation to OECD that mandatory binding arbitration, that is Articles 18 to 25, that it be applicable to DTAAs. That is the recommendation, but Indian tax administration has raised a reservation against it. So it is not at all clear that mandatory arbitration, binding arbitration, will be accepted by India that soon. Then the question is, leave alone, therefore, baseball arbitration is not something which is something that it is presented as a this case or that case, and the panel picks it, and the parties have to accept it. India certainly will not go for it, the administration, even though the tax experts believe that that is the way it should go. So instead, the non-binding independent opinion, where the panel looks at the tax treaties, the domestic laws, give their reasoning and therefore their position, that probably is the way countries like India, developing countries like India, will prefer. May also because one has to remember there are questions that such countries have come in only very recently to fora like the OECD, and therefore the trust and to withstand the pressures they feel are quite a lot, and still they are taking steps. And many other developing countries, for example in Africa, look up to countries like India and South Africa to see where they are heading and whether their interests are being protected. So but the question is, Indian experts are raising the issue that India actually has accepted trade arbitration, that is arbitration in international trade. So why cannot it be carried on to the tax area? And this is being discussed, but there are lots of arguments, official arguments, against adopting trade arbitration or adapting trade arbitration to arbitration in the taxation area. So finally, the issue is, so from India's point of view, the MLI, what is it? What does it provide to India? India's position on Article 16 of the MLI is that it already complies with the minimum standard as stipulated in Article 16, which allows an aggrieved taxpayer, that is a taxpayer who is opposing the tax administration's position, to approach the competitive authority of the country where the taxpayer is resident, which is not India, which let's say is the United States. So the taxpayer who is resident in the US and is paying tax in India can approach the competent authority in the US. However, India does not agree that such competent authority, that is competent authority of the US, can implement a bilateral consultation process with the competent authority of India. That is not automatic. While the taxpayer can approach his competent authority in his resident country, that doesn't mean the competent authority in his resident country can approach the Indian competitive authority and automatically start a bilateral consultation process in cases where India does not consider the taxpayer's objection to be justified. So if India feels that the taxpayer is wrong, which is of course the case, otherwise the taxpayer would not be dissatisfied, India reserves that right And therefore, it is again an area that remains unresolved. In fact, the multilateral MLI says that two countries must accept the decision of arbitration panel. But of course, taxpayer can reject the decision. But it applies only where both countries that are signatories of the MLI have notified their willingness to subscribe to the rules. In this sense, this is my last point down there, is that it is a kind of a consensus approach by the OECD. Now, some tax experts in the country believe that since the OECD has proceeded on this consensus approach, when will the tax world really reach a point where everyone moves together without too much disagreement? But the reality is, from the cases of emerging economies such as India that I gave you, you can see that on this matter at least, without the consensus approach, the OECD, which is after all a kind of a voluntary organization without any power to really impose its conditions, that this is the only way to go. They cannot impose conditions. It has to be a consensus approach, and that consensus approach so far seems to have led and guided the world in bringing together slowly. It could have been much faster, no doubt, but slowly to a point of much agreement and quite a lot of disagreements. As I said, sometimes the disagreements are minute. And to end, therefore, countries such as India cannot, of course, they participate now very intrinsically with the OECD, but they cannot, of course, agree with all the positions taken in the OECD because they are also exemplary to other developing countries. And that's why I think the OECD's consensus approach is a good one. Thank you very much.
Thank you very much, Bertho. Lisa, would you like to make some comments regarding this?
Thank you very much, Anarela, and thank you very much, Partho. I think it's a great opportunity to be joined by private and public and academic sectors like this. So I want to thank CIAT and Tribute for organizing this event. First of all, I am a revenue official. But I want to be a little bit provocative today because I think that's taking advantage of all the people we have on board today on the panels. So please do not think that my opinions or my proposals or my suggestions are something that is shared by my boss, the Commissioner of the Revenue of Chile. So please take them as my personal opinions, and I want to have a good conversation with you today and be a little bit provocative. So I hope that is fine with all of you. First of all, Partho mentioned that there are significant differences because our module in this panel is supposed to talk about developing countries. And of course, there are very different type of developing countries. In fact, in some cases, I think some small developing countries are more similar to small developed countries, and big developing countries are more likely to be like big developed countries. So there's different issues here, and I think we have to sort of look at those in turn, because I think Juan Carlos from Mexico mentioned that the amount of treaties that we have is less than Mexico, but we have like 33 treaties. We have since January 2000, which is 20 years now, have had treaties, and we've had 8 MAP cases. So, the differences here is India, which I think Partho said more than 400, stock a year, and 8 in 20 years. And I think these are the differences that we are talking about. Like Mexico, we also have actually arbitration clauses in our treaties, about 1/3 of them actually, but they're not mandatory. And that reflects, I think, a policy view of our country, that we do think that we will end up with arbitration one day. That is probably what we will, it's the only real solution to the problem. But we don't want to do that unless, we have we walked the course of having more experience. And I'll tell you, those 8 MAB cases we've had, actually the last 2 or 3 years we learned very much. And this is a little bit part of what I want to share with you today. Are we sufficiently heard at the FTA MAP forum, at the OECD? I don't think so. But I don't think we should be either, because I think what the OECD MAP forum is trying to solve is these backlogs that I think Tim mentioned, the Canada, US, 400 cases in India. They are not worried about 8 cases in Chile over 20 years. And all of our cases actually been solved within the 24 months. So, that is not the problem that is being at the center of Action 14. And I fully agree with that. I do think that that's the right way they should. They shouldn't sort of perhaps spend too much time and money on our cases. However, I do think, and here is when I want to be a little bit sort of provocative. I think there are things that we could do at the MAP procedure level. And I think these are not only things for developing countries. I think these are things perhaps that could work for everyone. But I do think we particularly see it, at least from my experience, we see these problems. Let's have a look, for instance, at Article 25, paragraph 1. It says, the case must be presented within 3 years from the first notification of the action resulting in taxation not in accordance with the treaty. 3 years. And what is the first notification of the action? If you go to the commentaries, and then, if you look at the inclusive framework, why would I go to the commentaries of the OECD model? I have not signed up to it. I might not even have read them when I signed up to a treaty. But in that commentary, the first notification actually means the notice of assessment. Surprise? Why does it talk about first notification of the action resulting in? And then in the commentaries, it explains that that is actually the notice of assessment. Now, in these areas, and this is what I want to sort of highlight here. In a procedure, I think these timeframes, the issues, the procedure has to be absolutely clear. And I think the problem for many of us, at least, who's sort of starting with MAP procedure, is that there are sort of rules set by perhaps these 10, 15 countries that didn't have 400 cases a year that are obvious to them, but they're not obvious to the rest of us. And that's where, you read in the commentaries things like, it should be interpreted in the way most favorable to the taxpayer. Now, I'm come from the revenue. I'm not going to interpret anything most favorable to the taxpayer. Then I would be out of, I would be out of my job the next day. I don't think my commissioner would like that very much. I think what we want to, we are rule of law, and we shouldn't have discussions of when, for instance, these 3 years starts and the time frame of it. Now, so what my provocative invitation now is, shouldn't we try to sort of at least get the MAP procedure a little bit more solved and clarified so that we know when this time frame is starting? And secondly, the other thing that I wanted to sort of comment on, shouldn't that 3 years be reduced? If you want to have tax certainty, why would you have to wait 3 years after a notice of assessment in order to get the process done with the other country? In fact, the OECD model, when it says you know, there's nothing stopping you from asking for initiate the MAP procedure earlier. Why don't we recommend to the taxpayer that once you start a first adjustment, get the other tax administration involved immediately? Because I think it's in the interest of all of us to have short statute of limitations. We want to have tax certainty. And the best way to do that is to get the other tax authority on board as soon as possible in order to make sure that things are actually, it's a sort of semi-APA, you know, but this is more of a sort of getting the other tax administration involved. So these are a little bit of my provocative comments. And I think just another few comments as well about the funding. I think this, I've heard, you know, $30,000-$40,000 to do some procedures in the US. It makes us a little bit interested, to be honest. But once I mentioned it in our ministry, it has been sort of looked upon with big eyes. You know, will we charge to make, you know, to do our work? So, but the thing is, linked to that, some of the cases that I have seen in our administration, some of the 8 cases that we had, has been dealt with less than $5,000. Honestly, are we really wanted to spend the time of tax administrations dealing with $5,000? So I think there is also procedure here on how to sort of best use our resources. So what I'll say here, I want to hear a little bit of what Partho says, what he thinks about my provocative ideas, and perhaps also Tim and Philip and Juan and Hans and Natalia, whoever he wants to come in with some comments on my ideas. Thank you.
Shall I, Annarella? Initial response? Yeah. No, I think, Lizelot, you are absolutely correct, because not only MAP procedures, but other elements also seem extraordinarily long. Now, if you actually look at some country experiences, that 3 years actually is lower, is a shorter duration than currently prevailing time lapse between assessment and initiation of MAP. So, so I'm sure, though I'm not privy to that, but there must have been a lot of negotiations and to come to this 3-year number. So maybe to begin with, the 3-year number was essential to come to some kind of equilibrium and some kind of solution. However, I would agree with you if, for example, if the phrase was inserted with a keen eye on a continuous basis to see the practicality of reducing 3 years to wherever possible and as soon as possible. I mean, with that intention. But it couldn't be made from, let's say, 3 years to 2 years, because I'm sure that there would be a lot of objections to that. So, but I think it's an excellent idea to constantly stir the pot, because certainly the whole process of BEPS actions of the MLI, as well as the pillars, they have to keep on changing and improve. But I don't believe that we can come to very quickly to or we can expect that number 3 to come to another concrete number, which is significantly lower. But a phrase to qualify the 3 years should certainly be something that could be pushed by both experts, tax experts in the private sector, as well as by dynamic tax administrations.
Thank you, Partho. Tim or Philip or anyone else?
Yeah, I've got a couple of reactions. One is, I think I know where the 3 years came from. In the US and in some other markets, you're entitled to administrative appeals before you can go to MAP. And depending on the case, that might be appealing, that you think the initial assessment doesn't pass muster, you may not need to invoke both countries. So our philosophy, at least from a corporate standpoint, I would say the accounting disclosure and accrual of tax liabilities motivates us to move the process along, because the uncertainty and the longer duration means we have to carry more tax reserves. So it wouldn't be, in P&G's case, we'd sit on the case and wait for 3 years. We'd either file as soon as we could, if we're going MAP, or we'd go to administrative appeals, see if we can resolve it there before we go to MAP. But I can't think of a sound reason the corporate community would slow it down, other than choosing your remedies. MAP can always be better. One of the things we often do, and it's with government permission, I alluded to, we have 16 APAs. They're remarkably almost identical in result. And we've had demands in more than 3 or 4 countries where a local audit theory suggests a level of profitability in the local market that exceeds the total system profit. And that just can't be an income tax. It means that, you know, we're working for the government. We're not an independent enterprise. So we tend to share our APAs, even in an audit context, to give the government a little bit of grounding as to what we've done. When we go to file an APA, we filed in 3 countries. We're the first ones to ever file. And when we do that, we know we're investing in the relationship, in an education process. The one thing we can offer that makes us sometimes an interesting candidate from the government's perspective is we can share all these, once again, with government permissions or redacting. We can show copies of the APAs, copies of the background submissions, the administrative procedures that a country has that helps gather what documents and how to present them. We can help them effectively shortcut the learning process. And the added advantage we can offer, if a government's never done this, there's a personal reputation risk for the official. They're out there sticking their neck out on a prospective ruling that they don't have to normally do. So why should they do it? And if they can get comfortable, this facilitates the treaty overall, because it front loads the work instead of back loads it. It does it when the cases aren't as solidified in entrenched position. It's generally a good thing for FDI and for commerce. But you have to have the confidence that you got it right. If I could show you 16 countries and they're all about the same, and because you're a developing country, I say, look, I'll give you 40 basis points more, just because I don't have great comparables in your country, but here's what everyone else did. And that's a pretty strong argument for a lot of countries. And so on the margin, if I don't have good comparables, I'm more willing to negotiate above the norm of these other rulings. We don't just put them on the table and say, take it or leave it. But I think that motivates countries to try to wade in. And when they do, the more experience they get, the easier and more obvious that path becomes. We've met countries and worked with countries that were very resistant 10 years ago to an APA or to different approaches. And if they get more than 3, if they get 10 or they get 15, they start to get a confidence, a cadence. And I think it helps the administration just deal with their caseload.
Yeah. Thank you, Tim. Philip?
Do you mind if I come in? Lieselot, I'm not certain that you were controversial enough about MAP. I personally believe that MAP is a very deeply flawed procedure and that it needs to be very, very fundamentally shaken up and changed. It's a procedure that originated almost 100 years ago. There is a lot of criticism of international tax rules that originated 100 years ago, and yet we're keeping this dispute resolution as the primary form of dispute resolution that originated at the same time. There have been lots of developments in international disputes that involve
corporates, participants, as well as states, trade disputes, and those have not impacted on MAP. 2 points. I can remember a period, maybe a couple of years ago, where over a summer, I think I saw half a dozen problems in international tax with clients, and they were all the sorts of problems that could have led to MAP. None of those problems was going to be resolved by MAP. Why? Because in some cases, they involve governments where the government had an entrenched view and the government was never going to move on that in MAP. There was going to be no point. In others, the government would say, we will go to MAP, but only if you give up any of your rights to go to the courts, and the taxpayer wasn't. One of those disputes was one that was just crying out to go to MAP. And I said to the taxpayers, what about MAP? And they said, been there, done that, never again. They'd gone through a MAP previously and they never wanted to go there again. The biggest problem with MAP is the lack of participation for the taxpayer. The taxpayer is outside the procedure and not inside participating. And the taxpayer knows the facts, knows the arguments, but is outside supplying information. If you said to somebody, yeah, the only way in which you're going to settle the dispute between, let's say, you and your partner is by going to this court. And the court can resolve the dispute, but you're not going to be there inside the court. You're going to have to sit outside and they'll come and send you messages and then they'll tell you what the outcome is. I don't think you'd be very happy with that procedure. And that's basically where MAP is. MAP is improved if you have arbitration, whether it's voluntary or mandatory. That resolves some of the problems, but we're going to come back to the arbitration point after we've had, I think, a short break.
Yeah. Just, I don't know if I can make a couple of points before we finish, and I think I will invite Parto as well to make some closing remarks on our model. So my idea would be to discuss openly. I really, one of the points that I didn't mention was the one that Philip mentioned about participation by the taxpayers in the procedure. The way that it's taken place as well. I think there are lots of things to be discussed. And I do think, thinking out of the box now, because I don't think this is a problem for, Action 14. I think this is a problem that, we might just have to look at, people who are worried about this procedure. It's actually to discuss a multilateral administrative MAP procedure so that we can sign up to some clear rules of, because I think the problem for developing countries, and I think here I speak in general, is that when we, negotiate tax treaties, we don't necessarily know what the MAP procedure is meant to be, because it seems to be a secret way of doing things in 15 countries that are doing it, have done it for 20 years. But if I read, as I said, the first notification, for me, that's the first notification. That's not the final notice of assessment, which the commentary says. Now, you get confused with these things. And I think that's where that's where I stand now. I would like clear rules, procedure, and speed. I think that we need that for tax certainty. I think that is, to me, something to move forward on. I don't think this is something for Action 14, because I think Action 14 is trying to solve a different issue. So just to finish with arbitration, I think in our case, adding to what Juan Carlos and Parto has said about arbitration and how our countries in our part of the world thinks about it, from our perspective as Mexico, we think we're going to end up with arbitration one day. That's why we put it in our treaties. However, with 8 MAP cases over 20 years, it's not a priority today. Because it's just, we can't spend our resources on something that has actually been two transfer pricing cases of $4,000. It is just not, you know, it's not really something that is the actual problem for us. We also need to have a little bit more of experience from MAP cases. So, you know, once you have discussed and see the issues, like, you know, like I mentioned now, I think you get more comfortable with it. Finally, I would like to invite you all. Action 14 is going to be reviewed. It's going to be public consultation. This is 2020, and it's up for review. So in autumn, European autumn, South American spring, at least spring in Chile, you are very welcome to please make comments on the public consultation document on Action 14. That would be very useful, I think, for all of us. So thank you. Parto, if you want to mention anything.
Yeah, just one quick point. I think that to elaborate, while I agree, and I would love to have MAP to be much more tightened and clarified, but reflecting what Tim was saying, there are many different administrative appeals processes which vary by country. So there can be first within department, within the administration, commissioners, then chief commissioners, then a tribunal, then an appeals tribunal, then the tribunal can go to the High Court, then from the High Court to Supreme Court, and in India sometimes from the Supreme Court you can come back to the High Court. So I mean, such domestic laws have to be changed within the administration. Also, if you can change those executively, that's fine, but that takes for many years indeed. Therefore, you know, it is not so clear. I'm not overemphasizing, but the practicality, the reality is, if you see some of the larger emerging economies, the way these systems operate domestically first have to be modified before internationally you can really play with the 3-2, etc. But and additionally, I would say that therefore, to link what Philip was saying, does it mean that MAP really cannot be reformed? Does it mean that MAP cannot be regurgitated from 100 years back and all that has happened and something new has to be invented? Even for that, Philip, I feel that tremendous international consensus is essential, and I don't see it because, as Liselott started her presentation, the US-Canada situations. In fact, many years ago when I was in Santo Domingo in Dominican Republic as chief guest of SIAD, on the beach, I was with the Canadian commissioner. And he said, you know, sometimes wars can be fought not on the front line, but over tax, like we fight with the US. That's my biggest worry. So tax can be a tremendous disagreement area. And I think to come to some specific numbers in the international taxation area, even among advanced economies, may sometimes be even more difficult. And we see also in the BEPS processes in Action 1 what happened and so on and so forth. So Liselott, I love your simple world. I believe in that simple world, but also there's a practical side, which I probably because of my gray hair, I'm coming more and more to accept and go along with that. Thank you.
That's it.
I'll just add one comment that I should have said in my section, which is dispute resolution is also a taxpayer obligation. And we do it as a fiduciary to our shareholders. We do it because in the US, if we want a tax credit, we have to prove it's actually an involuntary tax and it's properly assessed. What I would add is when I talk to some of my peers, they don't have a common approach as to how actively they participate in supporting MAP. And I think it's a huge mistake. We never give it to the advisors and the government and say, good luck, tell us how it turns out. We actively talk to both sides, or there's more than two, all sides. and we ask them what kind of analysis do they want, and then we present it to both sides. Do you want a more detailed functional analysis? Do you, whatever it is to facilitate it, because we think that more facts on the table does produce a better, quicker outcome. And the idea that you could passively toss this to third parties is completely foreign to us. But I know we're not universally, that's not a truth, because many of my peers just don't get involved in it. They don't have, I don't know if it's the budget or the appetite or management support, but for whatever reason, they just view it as, well, whatever happens there is the advisor's problem. And I think that's a huge mistake.
Thank you very much, Tim. Is Annarella, are we online?
Exactly. So I think we're just a little bit over schedule, but that's okay. It's been super interesting. We're not losing any participants, so it seems like everybody is fine to stay. We're just going to take a quick break, though, because we have been almost 2 hours. I'm sure some of you need to get a coffee or go to the bathroom, so we're going to maybe shorten the break to 5 minutes. At 8:46, 8:47, we'll be starting up again. So
Okay. Thank you.
thank you. All right. 8:46. Very strict 5-minute break. You couldn't get this in live webinar, in live seminar.
It is not enough time for a coffee, but just to
No.
rest.
Exactly. Philip, I see you're ready, and Natalia, you're there also. All right. So, thank you. The next session will be Mr. Philip Baker and Natalia Quiñones. I'll let you go ahead. I won't take any more of your time.
Thank you very much, Annarelia. Natalia and I agreed that it should be ladies first. And so Natalia is going to start, and then I'm going to follow after her.
Thank you very much, Philip. Thank you, Anarela, for all the great organization, and Gonzalo Arias. Special thanks to Hans Moy for coming up with this great idea. I think what we've seen so far in the morning really shows that there is a lot to be done on dispute resolution in Latin America. And I think, well, I really want to congratulate CIAT and Tribute for being the pioneers in starting to answer these many questions that we all have. So for this third session, we wanted to be practical. And in order to be practical, the first thing that we thought was very important was to talk about what's going on now. Because as Philip said, MAP was developed 100 years ago, and we live in a very different world, and especially a very changing world nowadays. If you see the statistics of tax disputes released last year in the Tax Certainty Day by the OECD, we're seeing an increased number of disputes everywhere in the world, and the increase is not small. It's over 20% of disputes, new disputes coming up due to the different interpretations that tax authorities might have in an increasingly complex network of rules in the international tax arena. Now we have general anti-avoidance rules, special anti-avoidance rules. We have BEPS actions 8 to 10 that bring more powers and more subjectivity to the table. So now we have a lot more room for disagreement. So I think partly this increase in subjectivity, in complexity, and in disputes has mainly been met by a shifting focus to prevention rather than resolution. I think the discussions on Pillar 1 and Pillar 2 and the differences that Partho mentioned on the standpoints of different developing countries have made it easier to agree on how to prevent rather than how to resolve these existing disputes. So I think in practice for everyone in developing countries, and especially in Latin America where they're listening, we definitely need to invest more money in the dispute prevention area. And I'm going to talk a little bit more about how we can go about that change. There's also something that we need to bear in mind. Lisa mentioned it, and I think Juan Carlos mentioned it too. There is increased pressure for tax certainty, for arbitration, for binding solutions. And this will be a reality, I think, sooner than later. And knowing this, we definitely need to prepare. If we think of today, we're in a much more leveled playing field. than we will be 20 years from now regarding arbitration. You know, most countries don't really have an experience of tax arbitration. So I think it is a good time to start learning and training and getting our acts together so that there won't be, again, a very large knowledge gap between the developed and the developing world. So this is, I think, a bit provocative, but we'll talk a bit more about that after Philip talks. If we can move to the next slide, Andrea. I didn't comment immediately on Lisa's invitation because I had this slide on enhancing MAP. I absolutely agree that we have to work on MAP in Latin America. Last year, the Colombian tax authorities went through this very exhaustive exercise of asking those questions, Lisa, that you've been asking, and we came up with domestic regulations where we tried to give some answers to some of these questions, administrative appeals procedures. So I definitely agree that we need to issue more guidance on what we mean with MAP and Article 25.1, and how do you count the 3 years, and what's the first notice of assessment translated into domestic terms, and the way we actually call our administrative acts. And this is something that we did in Colombia last year, but I think it's something we can all do together as Latin American administrations, with maybe CIET supporting us in drafting maybe a model MAP regulations, so we can have these discussions in common, and we can also have a strengthened, regional view on how these issues could be addressed. But definitely, when you are clear about the rules, there's much more movement around. We have that much fun experience in Colombia with MAP. But after we issued the regulations last year, we got at least 5 different consults for initiating MAP cases. So that means, once you establish rules, taxpayers are very willing to come forward and start, resolving the issues that have been long been unresolved. And this is something that is also true for our region. If we have to go through our domestic litigation procedures, we're risking over 10 years of waiting for a decision. And the 24-month period established in Action 14 definitely looks good compared to our domestic litigation timings, and also compared to the capacity building needs and the capacity that we could find in tax administrations as compared to our local justices, who are not necessarily experts in transfer pricing. I agree with Tim that having the taxpayer join MAP is absolutely important, and especially in transfer pricing cases. What we've introduced and what we would advise to have in every Latin American country is a joint taxpayer hearing, an opportunity to actually hear the facts. And I think this is especially important because the latest cases are about value creation. And I don't think we fully understand value creation as it is right now. Different countries can take different interpretations as to what adds value in each different business. But I think the ones that would know more about what adds value would be definitely you taxpayers. So I think you definitely should hear from them directly their interpretations of the facts and what adds value to their business in transfer pricing cases. I also think that Latin America, and I think the world at large, has underestimated the power of supplementary dispute resolution techniques. I don't know of any cases where a mediator is helping tax authorities reach an agreement in MAP, or where you get a non-binding expert determination to help the countries actually reach an agreement. And I think opening the door to these varied forms, binding or non-binding, like Partha was saying, it doesn't have to be binding, but it definitely aids in speeding up the process and getting the countries to agree so that we don't fall into this huge, inefficiency in MAP that Philip had already pointed to. I think we're still very far from dropping MAP altogether. So while we replace that system for a better one, we definitely could use some of these available tools that are very popular in other realms of law, but not necessarily tax, but that could definitely help our tax authorities come to agreements, and not just come to agreements, but also learn and get the experience that Lisa said we're lacking. If we definitely are lacking the experience, getting these experts, these neutral mediators to come help us, also probably mediators that have had much experience in MAP, then we will have some knowledge transfers that are quicker than resolving 400 MAP cases to get our confidence up. So I think really don't underestimate the power of SDR, and introduce opportunities for that in your local MAP regulations, definitely. I want to mention specifically 3 forms of this SDR that I think are very interesting for what we're seeing now in tax disputes. First one is mediation, and I think we got enough illustration from Juan Carlos when he mentioned the PRODECON acuerdos conclusivos. Those are a very effective way of introducing mediation in a Latin American context. They've received over 12,000 cases. They resolve over 2/3. Those statistics definitely inspire. So I think, there's a model out there. Why not look at it and try and introduce it? We have so many neutral experts out there that could be a part of a sort of Latin American PRODECON, or even a domestic one, if we can't yet get to to the more integrated side of things. I always say that the future of everything will be blurring national frontiers, because multinationals, they don't really see the world as a set of countries. They don't really have those borders in their minds, and I think the future of it is that tax authorities don't limit themselves to those borders either. And starting integration initiatives, such as having a Latin American PRODECON, a body with neutral experts that any authority could call to mediation in both domestic and international contexts, could also be a very nice idea that we could explore, and that CIAT could further. Conciliation is also a very effective way. It does need a stronger legal framework, and I know that nowadays and after COVID, passing legislation might be difficult if it's not for the recovery. But still, it is very helpful to have someone draft a solution for a conflict that has been going on for some time, if you've been having trouble resolving it, or if tax administrations are very determined in keeping their positions, as Philip was mentioning. So this could help evolve a position that has been very hard to change for an administration. Expert determination, I think, is full of possibilities, because you could choose domestic experts, you could choose tax administration experts from your own tax administration, and this could be used in all parts of the tax assessment process. You could have an expert review the assessment itself. You could have an expert review the final notice after the administrative appeals. You could have an expert review the case after it's gone to litigation. I think you can introduce this at any time. You can do it binding or non-binding. It's a very flexible way of aiding in dispute resolution. And I don't think you need that much of a domestic framework. I don't think you need to go to Congress to be able to get this, especially if you're going for the non-binding option. So I think this is something that definitely Latin American countries and developing countries generally should explore. And there's also lots of choices for independent experts. You could choose tribute experts, you could choose domestic experts, anyone that you feel comfortable with. So I think it's really full with possibilities and should be explored farther in a practical context. Next slide, Annarella, please. We've already mentioned ICAP, both Juan Carlos and Tim have mentioned the importance of it. I just want to mention that that this really should be reviewed again by all Latin American administrations, mainly because it's a great capacity building opportunity. You know, having your auditors sit together with auditors from 20 other countries, examining the same documents and reaching conclusions on what's indicated by those documents, analyzing transactions together. There could be no better training course than that. I don't think you need the most expert people necessarily sitting down all the time. I think ICAP is flexible enough so that you can narrow down the scope of the cases that you're looking at as a tax administration. And I think the fact that ICAP is still in its early stages, that it's in its 2.0 stage, is also important because the rules are still being reviewed and made. And I think, Latin American countries could definitely contribute to what Juan Carlos was suggesting, to a simplified ICAP model where you could have, a more narrow scope and where you wouldn't need that much dedication or that much capacity in your auditors, but at the same time, you would be getting all the goodness from exchanging in a very practical examination, sharing in the abilities and the knowledge of other tax administrations that have been doing this for maybe longer than you have. So this is just an invitation, I think, for reviewing this opportunity and maybe giving it a go. Next slide, Annarella. I really like a term that Mike Leonard first used some years ago in a seminar, in an arbitration seminar in Fordham that I shared with him. He said we could use a varied geometry in Latin America and the developing world at large. And I think this is absolutely true, and it matches Partha's and Lisa's observation of the developing countries being so different among themselves, large and small, emerging and low income. It's really having a menu of options where everyone can choose their favorite flavor. So I think there's some domestic efforts that we definitely can do now. And I definitely think we have to do something now. We saw the panorama of disputes. It's not going to stop. It will continue to grow. Disputes will continue to grow, and we won't gain anything by doing nothing. We have to gain more experience. Arbitration and other binding solutions are coming closer and closer to a minimum standard. And And there are some things that we can do in the meantime. The guidance, rulings, and otherwise are very important. And we can have guidance issued after working together with the taxpayers. This is also something that we did when we were working on the MAP regulations in Colombia. We invited some comments from some stakeholders. How do you feel about going this way, or having these administrative acts as the possible first notice under Article 25.1. And after, having the dialogue, we came up with actual, written guidance for everyone that is also open to being reformed and that could evolve given, other practical issues that you didn't see at the time of making the regulations. But sitting together and agreeing to how you're going to deal with these questions and issues is definitely something that we can start doing now. Then we also have to think of the legal framework. There was one question around from, I think, Mr. Viana from Argentina, on what happens if the statute of limitations has expired and you have a MAP agreement. There are some issues that you definitely need to implement via law, but it's something that you can resolve. I mean, you can have a legal power to implement a MAP agreement just as you implement any judicial ruling. Regardless of whether the year has its firm limitations has expired. So I think granting a suspension of terms and clarifying legal value of agreements, the implementation timelines is something that we can start doing. Maybe CIET and Tribute could help. And then again, we can start independent technical reviews, in-house reviews when there's a very difficult case. We have that in Colombia now. If there is a very complex transfer pricing case going on in a city that is not Bogota, then we get the case reviewed by experts in Bogota who have more extensive training and knowledge of transfer pricing before the final assessment is issued. And this is something that is done internally in the tax administration. And I think all tax administrations could implement a policy of having a technical committee established for the most difficult and valuable transfer pricing cases, for example. And then the public-private working groups on difficult issues. I think that's something that doesn't need any regulation. You can just do a Zoom and discuss beneficial ownership or transfer pricing or any other new and upcoming issues after the implementation of BEPS. I also wanted to say a final note on comparative compliance. I do see a lot of value in comparative compliance for dispute pre-focus to prevention. We'll definitely see an increase in implementation of comparative compliance programs. I know that many Latin American countries are starting pilot comparative compliance projects. I think in our context, it is very important to delineate the beneficiary group for the comparative compliance program, because there are issues for legal equality and whether you're offering this to just some and not all of the taxpayers, and if you can justify that you're offering it to taxpayers that have a different situation, that are in different circumstances because they have a specific flow of cross-border transactions or specific additional obligations in transfer pricing, then definitely you'll get the courts to approve the delineation of the beneficiary group. And then it's the same for the definition of the evaluation criteria. I think we should go for more objective indicators in the risk assessment. So we could have some flexibility, but you know, the more objective criteria we have, the more taxpayers will join, and the more experience, again, we will get before arbitration comes and hits us as a minimum standard. So speaking about arbitration, I would like to invite Philip to tell us about this very complex process.
Thanks, Natalia. I don't think it's necessarily a complex process, but I'm going to focus particularly some comments on arbitration. I mean, we all know what arbitration is. It's a form of alternative dispute resolution. It's a way of resolving disputes outside the courts, and the dispute is decided by one or more arbitrators or an arbitral tribunal, and they render an arbitral award, and it can be a much simplified procedure than the procedure that's actually followed in courts. There it usually would be. If we come to the next slide, the focus of next slide. The focus of this seminar is on cross-border disputes, but I thought I might just mention that arbitration, of course, can also be introduced into a domestic tax system. In preparing for this, I noted, for example, that in Portugal, back at the beginning of the 2010s, there was a huge backlog of tax cases. And so in 2011, there was a tax arbitration law introduced that brought in tax arbitration courts made up of one arbitrator or a panel of three selected by the parties. They were introduced to rapidly resolve disputes. There was no appeal from them. They were administered by an arbitration institute, the Center for Administrative Arbitration. There was no constitutional issue in that particular situation because the definition of courts in the Portuguese constitution apparently allowed for this. I noticed that we have a number of participants from Portugal. Perhaps maybe in the discussion, they'll tell us how useful that was in reducing the backlog of cases in Portugal. But returning to cross-border disputes and going to the next slide, we've spoken about arbitration following on after there has been an attempt to resolve a dispute by map. And that's the type of arbitration that I'm primarily going to focus on. You will know that there are now provisions both in the OECD model and in the UN model for arbitration. It's Article 25.5 of the OECD model and Alternative B of Article 25 of the UN model. The idea is that arbitration comes in if MAP has not resolved the dispute within sometimes 2 years, sometimes 3 years, if it depends upon the particular treaty. And this is something that is growing in treaties since the early 2000s. We've had some examples of experience from some countries on arbitration. Tim mentioned that under the US-Canada protocol, a form of arbitration was introduced almost 20 years ago. In fact, that proved relatively successful in encouraging settlement of disputes through MAP. It wasn't necessary for most of the outstanding disputes to actually go to arbitration. Instead, the fact that they could be taken on to arbitration resulted in the competent authorities resolving by agreement. And that's been an experience, I think, around the world where arbitration comes in. It kind of focuses the minds of the competent authorities and encourages them to resolve the dispute within the 2 or 3 years. Otherwise, there is the possibility of arbitration coming in. If we just go to the next slide, I just set out there the wording of Article 25.5. You'll see that it applies where the taxpayers presented a case to the competent authorities. The competent authorities have proved unable to reach an agreement, in this example, within 2 years. And then if you carry on reading onto the next slide, you will see that it says any unresolved issues which have not been resolved through the MAP, because the MAP may have resolved some but not all of the issues, then they are submitted to arbitration if the taxpayer requests. And in the OECD model, it's mandatory binding arbitration. The decision reached by the arbitral panel is binding on the competent authorities. The provisions in the OECD model and the UN model are very brief, and they don't give the details of the arbitration, the procedures. You'll see at the end there, the competent authorities have to settle the mode of application by mutual agreement. If you go on to the next slide, you will see that, in fact, to help the competent authorities, both the OECD model and the UN model set out a sample mutual agreement on arbitration, something that the competent authorities can use a model text for the agreement that they will enter into, which implements the details of the arbitration. And that mutual agreement deals with time limits, appointment of arbitrators, type of arbitration, all those details there. That is arbitration under Article 25 of one of the models. It's also been mentioned earlier today, if we come on to the next slide, that under the MLI, the Multilateral Convention, there is an optional code of arbitration in tax matters. It's part 6 of the MLI. It's a whole chapter, a whole part of the MLI dealing with the details. So this doesn't have to be implemented by a subsequent mutual agreement. The part 6 itself contains detailed rules setting out the type of arbitration, the appointment of arbitrators, issues like that. Of course, it's optional in that it will only apply if the countries concerned agree to extend part 6 to their covered tax agreements. And some countries have been willing to do this. Some countries have indicated that they would prefer to proceed on a bilateral country-by-country basis with regard to arbitration, rather than adopting the rules in part 6. If we go to the next slide, there are some details that I wanted to fill out here. In terms of types of arbitration, we've used several times this morning, the term baseball arbitration, or last best offer arbitration. I wish it wasn't called baseball, because I'm British and I don't understand baseball. I understand cricket, and I wish it was cricket arbitration. But I understand that the origin of this is that in America, if there is a dispute between a baseball club and one of the players, and they want to renew the player's contracts, and the player says, I am a great player, I am worth $1 million a week. And the club says, you're not so great, you're worth maybe $1,000 a week. Then the way in which the dispute is resolved is by each party puts their offer, hopefully a more realistic one, effectively in an envelope, and then the arbitrator chooses between them. And this method has been applied in the tax context. So each party, the two competent authorities, submits its proposed award, what it thinks should be the outcome of the dispute. It provides a relatively short supporting statement, commonly 20 pages maximum. The arbitrators who are appointed then choose between those two positions. And that's all they can do. They cannot substitute their own views. They just choose between those two positions, and they do not give any reasons. Obviously, the arbitrators will themselves have their own reasons why they've chosen one rather than the other, but that's not made public. They will just choose it. And the idea is to come to a solution, hopefully a reasonable one, on a fairly rapid basis. You can contrast that with a reasoned award. And the MLI provides as an alternative for a reasoned award where the arbitrators do give their reasons for their decision. Their reasons may be kept confidential. They don't necessarily have any precedential value, but the parties then understand why the arbitrators have taken a particular view they've had in the outcome of the dispute. Baseball arbitration seems to be strongly preferred by some countries, and it's the preferred basis in the MLI, with reasoned award as a second fallback. If we just move to the next slide, if we may please. Point that I wanted to emphasize here is the importance of arbitration institutes. Many tax authorities have little or no experience of arbitration. They don't know how to go about appointing the arbitrators, getting the arbitrators to agree confidentiality, arranging for a venue, arranging for payment, arranging for time limits to be observed. That's where arbitration institutes come in. Arbitration institutes have been around for 100 years or more in some cases, and they exist partly to administer arbitration on behalf of the parties, and they will take over the administrative side. There are some very, very well-known examples. The International Chamber of Commerce has, as one of its functions, acting as an arbitration institute. The Permanent Court of Arbitration, which resides at the premises of the International Court of Justice in The Hague in the Netherlands, has over 100 years of existing as an arbitration institute. And in addition, there are many regional arbitration institutes set up in particular countries or regions that are willing to effect the administrative side of arbitration. Tribute has been working with the Permanent Court of Arbitration to act as a regular arbitration institute for tax matters. If we just go on to the next slide. In terms of who the arbitrators are, there is a wide and open choice on this. The arbitrators are chosen by the parties. They could well be retired tax officials. They could be retired judges. They could be existing or retired academics. They could be practicing lawyers. They could be members of international organizations, the OECD, the UN. The parties would choose who the arbitrators are. Tribute, that is involved in the setting up of this seminar today, Tribute has a list of potential arbitrators, and there's a URL there, a link to the address where that list is maintained. I'm prepared to go out on a limb a little bit and make a fairly confident prediction. There are, I think, 500 or so participants in this seminar. I'm prepared to predict that a good number of those participants, before they end their careers, whether as tax lawyers or academics, may well find themselves acting as tax arbitrators, because I think this is a very much a growth area. If we go on to the next slide, we could have a long discussion about the advantages and disadvantages of arbitration. And Partho mentioned some of the positions that India, the government, said on arbitration, and also some of the views taken by practicing experts in India. If you want to look at a discussion of the pros and cons, advantages, disadvantages, have a look at the commentary to the UN model, which in Article 25 discusses some of the advantages and disadvantages. I'm going to highlight very briefly a few advantages before I pass back to Natalia for some final comments in this part of the session. There. What are some of the advantages? It can be quick. It can be significantly faster than local courts. It may well resolve the matter within a matter of months. And that's particularly true where one's looking at baseball arbitration, where the arbitrators may have only a relatively short number of days to consider the offers, to discuss them amongst themselves, and then simply to make their choice. It may be significantly cheaper for all the parties than potentially involving over a lengthy period of litigation. The litigation may proceed through different courts and may end up adding costs both for the tax administration and for the taxpayer. To my mind, one of the very big favorable points for arbitration is the element of expertise. Let's accept it. International tax disputes, international tax law is becoming more and more complicated, and many countries, the regular judiciary that hear tax disputes do not have a necessary high level of expertise in international tax. That's not true in all countries, but in a number of countries, transfer pricing issues, tax treaty issues are not ones that the regular courts examine often. In the choice of arbitrators, you can choose transfer pricing experts, tax treaty experts, experts on particular aspects of tax treaties, and rely upon their expertise. And in most cases, the advantage of an arbitration is that it is a single procedure. You do not find yourself caught in appeals from one level of tribunal to another. That varies again from country to country. In some countries, an arbitration can end up being challenged in the local courts, but in most cases, the arbitration will end the matter. To my mind, there are significant advantages in arbitration, and as I mentioned a little earlier, I think it in some ways resolves some of the problems of MAP. That's what I wanted to say about arbitration, and if I may, in the last few remaining minutes, can I pass back to Natalia for some final comments?
Thank you very much, Philip, for this very important view of arbitration. Because what I gather from what you said is that many of the preconceptions that we usually have in Latin America on arbitration can actually be bridged and overcome. The costs, the difficulty in the procedure, we have the tribute and other venues that can help with that. And what we heard from Lisa and from Juan Carlos is that countries are already accepting arbitration, even if it's in a non-binding form in some of the treaties. So I think this is really a very good moment to pause and reflect on all these choices that we have on implementing arbitration and agreeing to it in our tax treaty network. Like Juan Carlos mentioned before, it's a very valuable negotiating tool. We actually had a conversation with Natalia Istizabal, who's here, on whether we should accept arbitration in the MLI or not as Colombia. And I think what drove the decision not to go with arbitration in the MLI was precisely that it becomes a very valuable negotiation tool. You can renegotiate your existing treaties by offering arbitration in exchange for more source taxing rights, for example, under other articles that are more flexible, like Article 13. There are really many options where we can start working on this and getting the experience that we need. And what Philip has told us is that we're not alone. There's a support network of experts and venues that are very happy to help. And there's also CIET here offering this webinar and probably offering many more steps after this to support tax administrations in getting through with this. I think for some final remarks, I just want to remind participants of the pressure for taxpayer certainty and the wider adoption of arbitration in the MLI, how it will speed up the introduction of arbitration as a minimum standard at some point. And we are really in a point where we can close the knowledge gap. If we start training, we're going to be just like many other European and developed countries that have not really had any arbitration cases yet. So definitely there is an opportunity for training. We have those online training icons here in this slide, also because, you know, COVID has brought an opportunity to enhance global trainings through digital means. I also want to go back to one question that Juan Carlos asked about the post-COVID world. And I do see an opportunity here for SDR and ADR in tax disputes. Tax administrations will definitely be more pressed for raising revenue, and waiting for 10 years in courts, in domestic courts, is definitely not the best choice in a post-COVID world. If we can speed up the recovery of some of those disputes that are clogged up in the domestic litigation system, or some of the audits that we're very sure about that we're conducting now, if we bring SDR to those, then we definitely can speed up the gaining revenue from. We saw that we can charge for APAs and other, you know, cooperative compliance programs. Let's try and use this opportunity also as a revenue raiser. So I would invite and encourage all tax administrations here present to examine those opportunities also for a post-COVID-19 world. And a very last and final remark for those who have very firmly opposed arbitration for so long. Nothing is permanent, really. And the Buddhist teachings on impermanence, I think, are pertinent right now, in that this is a very rapidly changing world, and we have to be willing and open to change our views, like the Indian administration did with BEPS 14 in allowing for MAP in transfer pricing cases. We have to be open for allowing for arbitration at some point, because it will get here soon. Philip, do you have final remarks?
I don't have any final remarks. We have, we've just gone over, I think, into conclusion and possible extension. There are some questions in the Q&A, but I'll take my instructions from Anna Aurelia. Anna Aurelia, what would you like us to do now?
Thank you very much, Philip. Well, I guess we can throw out a poll question and see if people are willing to stay on a little longer in order to answer the questions, because yes, we are going to go into overtime. So if the audience is willing, and if you, the panelists, are willing to give us a couple more minutes of your time, which it seems like they are, then we can go into the question process. I believe 87% of people are saying that they would like to stay and hear you answer some questions. So let's do that. Let me start with the first question from Horacio Vania. Perhaps Tim or Philip, since you guys explained more about baseball arbitration, you can take this one. Does baseball arbitration plus confidentiality really provide legal certainty? How viable is the arbitration for transfer pricing disputes, considering the experiences either in the UK or in the US?
Tim, have you had some experience of that?
We were an audit and an APA in Canada while the treaty was being implemented, and we definitely saw the change in behavior firsthand. The audit division had taken a pretty aggressive point of view. We have kind of routine risk distributor in some manufacturing, but not a lot. It's managed and served mainly from the US, and that's a function of geography more than anything. For a long time, from a tax standpoint, I'd be better off with more activity in Canada than the US. But the nature of the geography is, I think it's 90% of the Canadian population lives within 60 miles of the US. And so our advertising is not distinguishable other than local branding. We might put a Canadian maple leaf on the label, but the fact is the consumers are almost homogeneous. So we manage them together, and we were trying to get certainty. And once the arbitration clause became effective, the nature of the dispute accelerated, the entrenched positions kind of dissolved. I'm not even aware that there has been an arbitration resolution under the treaty. It's the mere threat that you have this take it or leave it that produces the negotiation in the regular MAP case. And that experience convinces me that this is the likely endpoint for dispute resolutions. It may take countries different paths to get there, but mediation and general arbitration are more expensive. They tend to reward entrenched behavior, and therefore you can always walk away in mediation. It's not a whole lot different than a MAP, which is an agreement to agree. So ultimately, I think the clarifying effect is much more powerful than the actual activity of arbitration.
Perfect. Thank you for
I'll
that.
just
Yeah,
add
Phil?
briefly to that. I think the question asked, first of all, about confidentiality. Arbitrators are required to sign undertakings of confidentiality because they don't work for tax authorities, and so they're not under the normal obligations. There have been a small number of arbitrations, for example, in Europe, under the European Arbitration Convention. Very, very little information about even the fact that they've taken place has come out. So I think confidentiality has largely been observed. In terms of baseball arbitration, I guess it's disappointing not to know the reasons, but if it's horses for courses. If you're looking as a taxpayer to make certain that the two tax authorities both take the same line, for example, on a transfer pricing dispute, so that one makes an adjustment and the other one makes a corresponding adjustment, that will not necessarily mean that you are where you would have preferred to be, but at least it should ensure that the two countries are applying the same transfer pricing approach. And that's the attraction of having a resolution, whether it's explained or not. So it will not be perhaps the ideal method of solving all international tax disputes, but ones where you want to have the two tax authorities taking the same view. If I might ask, just add to that, one of the questions in the Q&A was, when I spoke a little earlier, I mentioned half a dozen clients who might have gone to MAP and none of them did. And someone asked, well, what did they do if they didn't go to MAP? The answer is, in some cases, they simply swallowed the unrelieved double taxation. They said, okay, we just are not going to be able to resolve this. We're just going to have to accept that there's double taxation on this transaction. We'll restructure for the future. I know that in one case, they decided to litigate in one of the countries, hoping that they would then be able to persuade the other country to accept the outcome of the litigation, which is a suboptimal solution, because the whole idea of MAP is to have both countries accepting the same outcome.
Perfect. Thank you very much, Philip. We can move on to the next question from Suchint Majmudar. Sorry, I probably did not pronounce that name correctly. But the question is for session 2, Lisa and Partho. Suchint would like to agree with your point about expediting the filing of MAP. And she's wondering, or they're wondering, especially with COVID-19, it's likely that disputes will balloon, and therefore recourse to MAP or bilateral audit settlements at the time that the audit is initiated is a useful mechanism, as Partho mentioned. And the question is, would there be a third alternative, a midway between a MAP or an APA? Lisa or Partho, would you like to?
I mean, I think going back to the commentaries, you know, there is nothing to say that the taxpayer can't go to MAP immediately. I mean, I take the point that Tim and Partho is saying about, you know, that the 3 years is probably from, you know, the remedies that has to be going through the other country. But, you know, it does say in the commentary, and then specifically even on you know, since the first steps in a mutual agreement procedure may be set in motion at a very early stage based upon the mere probability of taxation not in accordance with the convention, the initiation of the procedure in this manner would not be considered to be the start date for the arbitration clause. So, I mean, even the commentaries are saying that, you know, the MAP procedure can be started at a very early stage. There's nothing to say that you can't do it. And you know, I'm just trying to say that, you know, if you do want tax certainty, if you want to get results quicker, you should probably do that as soon as possible, because why should you wait until you get the final notice of assessment? I think Tim said it, and perhaps Partho as well, you get entrenched positions by then. It's very difficult to change someone's mind, you know, when you have gone through perhaps 5 years of negotiation over a deal. And then, you know, 3 years after that, you've even gone through perhaps even to a procedure at the court level. And then you're going to go and start and convince the other country. And, you know, it's just too late. And I think, you know, the commentary says this very clearly. You can go on a very early stage. And I think that's a recommendation one should do.
May I just say something very quickly here to complement what Lisa has said? We share that view in Colombia when we were drafting the MAP regulations last year. We precisely encourage taxpayers to come to us at the moment that they have something in writing. So whatever they have in writing from the tax administration will be considered by the Colombian authorities as enough notice to start MAP. They can even start consulting, pre-MAP consulting, when they've had verbal communications from the tax authorities indicating that there will be an adjustment. So I think this is something that each tax administration can regulate, and you're very free to clarify and encourage taxpayers to start at the earliest stages, like you say.
Perfect.
You're mute,
Partho, you're muted.
Yeah, maybe I can make a very quick comment. I don't want to cast aspersions on tax administrations, but there are countries where a tax administration, if they know that a MAP is already there, the appeals process and at the administration level in particular, but probably also in the tribunal, but certainly in the administration process, would be that, well, a MAP is going to happen anyway. So we will take a contrarian or orthogonal view on this, and then let the taxpayer go on with his MAP. That happens sometimes, for example, in transfer pricing cases too, that, well, there are all these appeals stages that you can go through, and sometimes it is discussed with the taxpayer that you please go to the appeals, because we have to take for our protection a very conservative view, because the auditor and accountants general of the country that oversees the behavior of administration, in particular tax administration, we will want to protect ourselves from that. Otherwise, we may be questioned as to why we took certain positions. So there again, I think that in more complex setups, the solution of, when you start the map and when you have the appeals process, whether they are simultaneous or sequential, is a little more complex. That is something that one has to keep in mind. But technically, as Lizelot, you have said, that there is no reason why they cannot start simultaneously, and therefore you can reduce the length. All I'm saying is that I would expect a strong opposition and objections from certain rather mature emerging economies to administrations to say, no, that is not our system, and we cannot. It's very simplistic almost. I mean, from their point of view. But if we can organize something that will make a kind of phraseology to open these things up a little bit, then I think step by step the OECD can proceed in that kind of direction. Thanks. Thank you.
Thank you. Thank you all for your answers. We can move on to another question. Unfortunately, we won't have time to answer all of them, but we can probably do two more. So from Rio Pinto, the question is, in addition to legislative measures, shouldn't countries consider preventative operational measures to avoid transfer pricing situations, such as the establishment of public international databases with comparables by sector, which could be managed by multinational organizations such as the OECD or the UN? Do you think this is a good idea?
Yes, I can speak because I see a lot of different geographies, and that might work in some markets where there's a pretty good database. You're still going down the path we've used for 100 years, which is transactional functional comparability. And that requires a lot of energy, a lot of expertise, quite frankly, a lot of budget for governments. And most of the inclusive framework does not have that kind of infrastructure. So Chile and Mexico are both OECD members. They're more experienced at this, but with, I'll take Africa as an example. ATAF, which is the African Tax Administrator Forum, they readily say that they don't have enough comparables in the universe of their transactions in these geographies, period. So if you don't have enough examples and they're not robust, I don't know how far that takes you. I'm hopeful that the digital project might take us to a formulaic approach that's much simpler and doesn't require all that analysis. That for me seems to be one of the big upsides if I think about each country's national self-interest in this digital project. It's clearly understood by the administrators. I don't know that for a lot of countries, they realize that there's over 130 countries in this inclusive framework discussion. And I think the number's pretty accurate. I've asserted in public forums and in documents submitted to OECD, our best understanding is there's only 40 countries that have a single transfer price economist on their staff. And then in addition, you say, well, do you at least have a database? Because you can license these databases. And it turns out there's probably only 60 countries that have a licensed database, an additional 20. So it means a majority of the inclusive framework doesn't have the tools to do a transfer pricing analysis. I think that's inherently a limitation on confidence in a new cross-border regime. And so I'm kind of hoping if we set a normative formula, hopefully based on reasonable economics, that we then get away from the database search that we continually have done for 100 years. And I think it's going to be difficult to do this. There's a number of countries saying they think the minimum distributor return should be 5% of sales. Well, the average public data right now, the Fortune 1200, the largest, most successful companies in the world, they average 12.5% profit as a percentage of sales pre-crisis. If you expand the scope of OECD is intended to be about 3,000 companies. And as you get smaller, generally rule of thumb, if the successful enterprises are both large and public, and although there's examples of private companies that are highly successful, most are average. And at the lower end, they're marginally profitable. They're trying to get to sustaining in size. And so if you think about a 3,000 multinational database, the average profitability is well below 10%. And so expectations are part of the problem. If you think you're going to get half the total profits and you're not making the product, you're not doing the R&D, you're not doing the risky stuff, I think we're going to have a problem getting a deal. But if we get away from the comparables, we'll be in a better place, in my view.
And Aurelia, I noticed that Maureen asked to answer that question. I don't know whether she's still on the call.
I'm not, no, I think she's typing out the questions that we're answering live, so she's putting them out there.
Okay, sorry.
Yeah, no, but that's fine. Okay, let's take one last question. Perhaps Hans, I don't know if you'd like to speak, or anybody from the group. The question is more specifically to transfer pricing. Which are the transfer pricing issues that most commonly end up in arbitration? Is it, she asked, is it specifically to do with intangibles for the most part? It's, and then I'm gonna put this together with another question that is complementary, is how to keep the arbitrator from in a fair or unbiased position. So which are the issues that commonly go to arbitration and how to keep it unbiased?
Yeah, shall I respond to that? Well, I mean, first of all, that is an almost impossible question to answer, because to date, no arbitration results have been published so far. So we have no information, no published and authorized information whatsoever where the arbitrations were about. That is a real miss, right? So we talk about, let's say, gain more experience, but if all of these arbitration results are being hidden from us, I mean, we don't have any possibility to gain any experience at all. So I think the question actually should be interpreted as a plea for publication. Now, I think luckily both the OECD and even more, I think the EU are in favor of publication, be it, let's say, an abbreviated version. But I think indeed that is adamant. The second question is, how do you prevent an arbitrator from being, let's say, biased? Well, that is a matter of selection, right? A matter of very careful selection. Now, I can only explain what we do at Tribute in selecting our arbitrators. That's an extremely careful selection process based on peer reviews. So it's not just, let's say, on the kind of information that a candidate expert provides him or herself. We have, let's say, a lot of lady experts also on the list. And there are ample, very good ladies around, I can tell you that. But it's a very careful peer review. At the end of the day, however, it is the authorities, the disputing parties themselves that agree who they want to have as an arbitrator. There are certain arbitration institutes that employ a list and appoint the arbitrators themselves from that list without the disputing parties having any say. But I think the common format at the OECD and the UN is that the disputing parties themselves agree on who they want to have as an arbitrator. The most sensitive position, of course, is of the chair arbitrator if you have, let's say, a three-party panel. And I think in Europe there is, let's say, a preference to have a former judge or even an active judge to act as a chair. I think that's basically to guarantee that impartial position. But I can assure you, I think most of the people I know, and certainly the people we have on our list at Tribute, know very, very well how to act fair and totally unbiased. It's not very often, I think, that parties, once having received an arbitral result, complain about the arbitral panel being unfair or unbiased. And think the only cases that I know, and that didn't happen in tax, but in other areas of arbitration, it was just the party who was, let's say, disappointed by the result. Well, that is a sort of a normal reaction, of course, but it doesn't say anything about the validity and the fairness of the result. I think Philip mentioned that ordinarily it's not provided for that there can be an appeal against an arbitral result. But what you do see in many of the procedural rules that are around is that disputing parties, competent authorities who are not entirely happy with the arbitral result still have a possibility within a limited time frame to agree on a different outcome. So some even say that for that reason, the arbitral result is not totally binding. But I think, yes, it's good. I think it gives parties, competent authorities, the possibility for a second thought, a second idea of the result, and something that you voluntarily agree on, I think is always better than a solution that is forced on you.
Great. Thank you very much, Hans. We have one last question that's getting a lot of likes, so maybe I'll ask that one. It's, I guess, for those of you in finance, maybe Tim, or I'm not sure, it's about investment arbitration. The question is, how do you see investment arbitration as a means to resolve certain tax disputes in the near future?
So I can take a shot at that. So this is, how does tax fit into the broader financial world? And a lot of tax practitioners think only in terms of there's the tax law domestically, there's a treaty, and that's it. In fact, both the investment treaties that exist and WTO principles require non-discriminatory behavior. And that non-discriminatory behavior in WTO, they call it national treatment, which means you'll treat the inbound investor no less favorably than the domestic, solely domestic taxpayer. And that principle is a strong principle, but it's rarely used. To try to argue a tax case in a trade forum or an investment treaty is certainly feasible. It certainly can be justified, but I would argue that's for those cases that are very extreme, because you're taking a tax matter with an expertise universe around it, and you're not taking it to a forum that doesn't have the expertise. So if you're going to take that approach, you better have a really clear overreach, a case that people could understand without the technicians that this is so far over the line that these other arguments become obvious. And we've actually made these arguments in 3 or 4 jurisdictional disputes, but we make them at the MOF level. We say, we're having this tax dispute, we want to resolve it, we can't get agreement to proceed for whatever reason the case. But here's the bigger issue. The bigger issue is your distributor theory asserts more profit than I have in the system for sales in your country. And that just can't be. It's discriminatory because I do have to pay tax where I made it, and I do have to pay tax where the intellectual property is owned. And if I have to pay those 2 taxes plus put all the profit in your country, cumulatively, I'm double taxed. And it's a de facto trade barrier.
Can I just add one thing? There is a couple of cases at the WTO on tax. The Argentina-Panama case being one of them. But most of the free trade agreements that at least Chile forms part of, they have a tax exception.
Right.
Because otherwise, the national treatment principle would just basically erode all our withholding taxes. So usually, I mean, it's applicable to VAT normally, but there is an exception in them. And now there's different, the free trade agreements and the investment treaties. The investment treaties we haven't had very much experience with, but the free trade agreements have exceptions. So that's just to add to that.
Yep.
Thank
Can
you.
I perhaps also add that, I mean, there is a growing body of arbitral awards in the area of international investment disputes and major contracts disputes, particularly extractive industry contract disputes. But I very much echo what Tim said, that most of the arbitrators who decide those are drawn from the commercial arbitration world. They don't have the tax expertise, and therefore they have to have the tax explained to them, but they come from a different background with different principles, and it's certainly not a route that could be regularly used for resolving cross-border tax disputes of the sort that we've been focusing on today.
And I think the WTO claim would be the stronger of the 2 claims. The investment treaty is even less a well-worn path. And I would say it's going to be more persuasive if it's in a country that has currency and price controls as well, because then the combination of a tax overreach plus other domestic laws may have the effect of confiscating the business or its profits. But I think other than that, the theoretical application is equal, but the practicality is the trade agreements. If you're going to go outside the income tax network, trade with an investment treaty commitments.
Yeah.
Thank you very much. All right, well, I think the group has illustrated all the progress being made in terms of dispute resolution and adapting it to developing country context. We've seen, thanks to Tim in session 1, how beneficial it is to have communication between business and government. What you said about how 80% of Procter & Gamble's transfer pricing is covered by APAs, that's impressive. That's an exemplary way to eliminate the skepticism that I think is present, the idea that the 2 sides, business and government, are in conflict. This is important, especially because it speaks to mutual trust. This was raised in the 2nd session and the 3rd session with not just business and governments, but tax administrations also can come together to coordinate, cooperate. There's tools and strategies such as what Liselott was saying with bettering the procedures for MAP and making that a little more practical, and just other ways to prevent tax aggression between jurisdictions. And finally, another note, as Natalia said, she said it for tax administrations, but I believe it works for taxpayers and tax administrations. You can choose your flavor or choose what you're the most comfortable with. And I think throughout this webinar, we have exemplified many options available in order to try and prevent more time-consuming and resource-intensive litigations. Because after all, isn't it better to mitigate and prevent the problem before it even starts? Especially when their technical capacity constitutes a limitation, as it does many times in developing countries. So that's it. This concludes our webinar. Thank you all very much for your active participation. Thank you to the panelists, Siat, Tribute, Gonzalo, and Hans, everyone.
Bye-bye.
Have a great day.
Thank you.
Bye, everybody. Bye. Enjoy the rest of the day.
Great presentation. We exceed the objectives.
Hasta luego.
Oh, great, Fausto.